we had just recently a ruling out of the Ninth Circuit in regards to California's 10 rounds limit on magazines. It's actually not just a sales ban, but a total ban on possession. Mm-hmm. Yes, it's a confiscation law. And that was upheld by the Ninth Circuit in somewhat unsurprising turn of events because they kind of uphold every gun. Yeah.
I was actually thinking about this. I'm not aware. I cannot think of a time, at least in recent memory, but probably ever, that they have thought that a state went too far. I'm not sure they've ever actually struck down a gun law.
I don't think at the en banc level, no.
Right.
At least not in recent history. And so I think we'll talk a little bit more about that case in detail on the news update with contributing writer Jake Fogelman. And hopefully the construction next door in my apartment will be done by then. And you won't, no one will hear the banging going on behind me. But I wanted to just get into a little bit more of the policy side of this. The justification used for these laws, for why they're presumptively constitutional in this case.
Right.
I wanted to get your thoughts on the argument that's put forward about them, that essentially they do not burden the Second Amendment, that they are restrictions on effectively weapons of war, guns that are designed for the battlefield.
Right.
What is your take on that? Is this something you hear a lot, right?
Right. And this is what's interesting sort of with this more progressive, less sort of text history tradition centered approach to law, is that it really becomes this policy interest balancing test, which, when you read Heller and McDonald, it explicitly says interest balancing is not appropriate for dealing with fundamental rights. And nevertheless, that's sort of what we get. Now I'll skip over sort of the legal aspect that, you cover in your news section. But it is important that, what ends up happening when you go through this is you're essentially reading the majority, introducing policy and balancing this policy in order to say that it's constitutional because it's, essentially a reasonably good fit for this government interest of reducing gun violence. And so, like you said, they go through sort of point by point. I think there are basically four main points with this that they make. And if they sound sort of like your standard gun control-esque talking points, it's because it's largely what they are. So, first you have this general, it doesn't outlaw weapons. It's only the size of the magazine. So it's not this massive infringement. It's not like they're banning handguns like in Heller. And then they go into this idea that there's no evidence that anyone has ever been unable to defend their homes or their families due to lack of having and I hate this term, large capacity magazine, call them standard capacity magazines.
Right, because most guns now come with magazines equipped with more than 10 rounds. Even your single stack carry gun these days will come with magazines that hold more than 10 rounds, and those guns are tiny.
And I'd say arguably the ones that don't, it's because gun manufacturers know that they have to deal with certain states, like California and the District of Columbia and New York and New Jersey that will sort of limit them in that way. So that, there is a forced market for it. But they are just pretty standard magazine capacities. And so this idea being, well, it's not a significant burden on the right to defend yourself, in your home or elsewhere. And then on the flip side, what they'll say is, but at the same time, this limitation is important because it saves lives in this case, and generally they specifically point to in mass shootings. And so therefore it, and I'm quoting here, reasonably supports the state's effort to reduce the devastating damage wrought by mass shootings. And I hope we get into that because that's, as someone who studies mass shootings for a living, that is an insane statement. To say that, well, the justification is this is what's going to really save lives in the long term. And underlying all of this is a thread of argument that you brought up, is that these sorts of magazines, over 10 rounds, they have this limited civilian function. They don't really benefit civilians, and that they're actually just weapons of war. And this is what the court says here, is that they are most useful in military service and trying to compare them to M16s, which, get you into some dicta language in Heller about how, maybe those aren't protected. But that's sort of this underlying thread is that, well, the civilians don't really need them. The military does. And so therefore, of course you can regulate them. Of course you can ban their possession for normal, just ordinary standard civilians because they're weapons of war.
Of course, there's a serious, caveat in this law in California and in most of these laws on regulating magazine size and AR-15s and AK-47s and similar firearms, which is that they don't outlaw them for police. They make exceptions for police. And in fact, even police who aren't on duty or even police who aren't serving anymore. Right. So there sort of leads this question as to why, if the argument is that you don't need these firearms outside of a battlefield, why in the world they would want the police to have them? Isn't that a common critique of policing in America today, that it's too militarized?
It is funny that those are the same arguments being put forward by people on the political spectrum who tend to also be in favor of demilitarizing the police. But you're right. This is not unique to California. This is actually, as far as I'm aware, an exception that it has been made in all of the 8 or 9 states that have, done similar types of bans, including, I think, Colorado now is at 15 capacity, at least for new purchases. And I'm fairly certain they exempt law enforcement as well. That you're right.
For now, they usually start at 15 and then they lower to 10. New Jersey and California have both done that. Right.
That it's not just law enforcement officers on duty, which that in and of itself, I mean, the idea there that that these are not peace officers operating in a civilian context. Your law enforcement officers on duty are not showing up to battle in military service, right? They are showing up to the exact same types of civilian threats that the rest of us faced in the first place, which is why we called them, to come and deal with this. They're dealing with those same types of civilian threats. So even just limiting it to while they're on duty, it sort of raises the question of, well, aren't you then essentially assuming that there is a legitimate civilian defensive function for this? But then you're right. They take it a step further and say, current officers in their civilian capacity can keep them, as well as former law enforcement officers who are entirely in their civilian capacity now. And what I tend to see is this argument. So you saw it both in this opinion out of the Ninth Circuit, and you see it all the time, just generally in the gun control argument is, well, but you see these officers, they're well trained in using these weapons, which I'd argue sometimes is not the case. But also we're not, that the underlying argument here has never been about, well, you need more training to have these. It's no, these are weapons of war. And if they're weapons of war, it doesn't matter whether you're well trained. Why do civilians have them? So it's just sort of this mix and match of arguments, and the fact that these exceptions exist just sort of belies that argument and undercuts all of, any sort of legitimacy that argument might have had, because you're giving them to officers in a civilian context, as well as, former officers who are entirely now in a civilian context. I mean, if this is about true threats, right, that this idea of the likelihood of a person possessing that magazine, using it in an unlawful way, I mean, it is objectively true when you look at the studies that concealed carry permit holders are statistically less likely to commit violent crimes than police officers, right? If that's what it's about, the likelihood of committing crimes, then you should exempt, concealed carry weapons permit holders before you exempt cops. Like, it just doesn't make a whole lot of sense. But alas, this is sort of what it has come down to from an interest balancing policy perspective.